I accompanied with him, I guess.
I'll let you do that, just in case he's having an issue hearing.
Neither of us hear very well, and I can hear, so I think right here, Corky.
So I've
Corky.
got
Oh, just go sit on,
Corky, just sit
right
right
there,
here.
right over there.
Do you want a hearing device?
Huh?
Do you want a
Do
hearing
you want a
device?
hearing aid or anything, Corky?
Yeah, I got hearing aids at home, but I can't stand them in my ear.
We have a court hearing thing, if you want to use that.
Want some earmuffs?
Huh?
They'll probably give you some earmuffs. Do you want them or no?
Earmuffs?
It goes over your ear.
It's just like a Bluetooth, the old
show
Bluetooth kind
you.
of things for phones.
If you don't like it, you don't have to use it, but it's neat because it goes through the microphone system.
Something that's gonna go over your ear and probably just sit kind of there,
Yeah.
so you can
Yeah,
hear
yeah.
a little better.
Okay, up for louder, down for quieter, but it just sits right over the ear.
Oh.
Yeah.
Like this?
That's what it looks like.
Yes. Can you hear right now? Can you hear better?
Pause. This is something people don't usually notice in courtroom videos, but it matters. Before any legal arguments, before any rulings, the judge makes sure the defendant can actually hear the proceedings. That's not just courtesy, that's due process. If someone can't hear what's happening, any ruling could later be challenged as unfair. Courts are required to make reasonable accommodations. And this small moment, it protects the integrity of everything that follows. Also, notice the tone. Calm, patient, respectful. This isn't TV drama. This is real courtroom procedure. But don't get comfortable, because in just a few minutes, someone is going to miss court entirely, and the energy will flip instantly. Stay with me.
Yeah,
Excellent. We will go on the record in 25 CV 14 Select Portfolio Servicing Inc. versus James P. Mulligan, Special Administrator of the Estate of Beatrice B. Reese. George Buskirk, Kelvin Buskirk, U.S. National Association, Department of Workforce Development, Wisconsin Department of Children and Families. We have appearing today George Buskirk. No one else makes an appearance. This is a hearing as it relates to the surplus funds from this foreclosure. There are $3,831.84. No one else is seeking claim to that money. We do have George Buskirk appearing today. Therefore, based upon his appearance and no other appearance by any other party, the court is ordering that the $3,831.84 be paid to George Buskirk. For the record, Kelvin Buskirk is deceased, and the court has not heard anything from the special administrator of the Reese estate.
Okay.
Okay, do you have any questions?
how come they keep bringing Kelly Busker out? He was the first one to pass away.
Just because he was still listed as a party,
His name must have been on
and
it.
he is not he's not really a part of this because he is deceased. I don't have the estate here, so I find them in default for failing to appear. So at least at this time, it'll be paid to George Buskirk.
That's me. Ooh, I can hear myself good.
Okay. All right, thank you. Then we are adjourned.
Yeah. We can go.
We'll go on the record in the matter 25 CF 145, State of Wisconsin versus Jacqueline Shabayesh. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski making a special or not making a special appearance. He's appearing as defense counsel in person. Ms. Shabayish appears by telephone conference with approval of the court. We're set for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. The parties have reached a resolution in this matter. Ms. Shabayish has agreed to accept the state's offer, a plea to count one in the complaint, dismissing and reading in the remaining counts, joint recommendation between the parties for a period of 2 years probation, withheld sentence, and court costs. I think we just at this point need to get a plea and sentencing date scheduled.
All right. I can do it either next Thursday at 10:30, or I can do 10 o'clock on that Friday, the 30th.
Next Thursday will work, Your Honor.
All right. So let's do Thursday at 10:30. That means Ms. Shabayish must be here in person.
Yeah.
Anything further, Mr. Feliski?
No, Your Honor. Thank you.
Okay, thank you. Then
And there it is. 9 minutes late, and now there's a warrant. Let's break this down. When a defendant fails to appear for a scheduled plea and sentencing, especially when weather and road conditions aren't an issue, the court treats it seriously. Why? Because court scheduling isn't casual. Prosecutors, defense attorneys, staff, everyone is present and ready. When someone doesn't show, it signals one of two things: disrespect for the court, avoidance of consequences. The $250 cash-only warrant means he can't just sign a bond and walk out. He must physically post cash before getting a new court date. And here's the subtle but powerful line: only judge may quash. That means no automatic fixes, no shortcuts. Now think about this. One person just got $3,800 in surplus funds calmly and respectfully. Another just earned himself a warrant in under 60 seconds. Same courtroom, completely different outcomes. And we're not done yet, because the next case, it's about strategy.
and we are adjourned.
Thank you.
Thank you. Plea and sentencing. All right, we will go on the record in the matter 25 CM 111, State of Wisconsin versus Matthew Richards. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Adam Benson in person. We do not have Matthew Richards. He fails to appear. This matter was set for 9:30. It is 9:38. There are no driving conditions to worry about. Roads are clear. We were set for a plea and sentencing today. Again, he fails to appear. Mr. Benson was provided the number that the court has in the electronic file. It was not working. Mr. Vila, what is the state requesting?
I would ask for a warrant, Your Honor.
Mr. Benson, would you like to argue or stand mute?
I would stand mute, Your Honor.
Thank you. The court will issue a warrant, $250 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned.
Thank you, Your Honor.
Thank you. Ms. Benjamin, your case is not until 9:45. I do not yet have your attorney, but when we do, we'll be ready to go at 9:45, okay? We're going to call Mr. Eads' cases. We will go on the record in the matter 25 CF 127, 25 TR 780, 837, 838. State of Wisconsin.
And that's court for today. 3 cases, 3 completely different outcomes. One man calmly walks away with surplus funds. One defendant skips court and leaves with a warrant. Another shows up prepared and gains legal leverage. Same judge, same courtroom. The difference: preparation, presence, credibility. In court, it's not always about who's loudest. It's about who's ready. Which case surprised you the most? Let me know below.
Versus Michael Eads. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Eads in person with counsel Daniel Chapman. We're set today in these matters for status conferences. Mr. Chapman, please update the court.
Your Honor, I have the discovery packet. I'm still looking into a matter regarding his second offense from 2003 in Douglas County. Have not received a call back from their clerk of courts. And there is a Miranda issue that I just received the search warrant affidavit today, and it's implicated in the search warrant. I need to research whether it's an issue that I can pursue.
For this case?
Yes, if I could just get one more status date, I'd appreciate it.
Yes. You mind if it's like 60 days out?
No, Judge.
Oh, wait, I went the wrong week. Oh, I can't. So it'll be a little bit over that. Are you okay with that?
We're not in a rush, Judge.
I can do 10:30 on March 30th.
I am in Dunn County at that time.
Dunn County, could you do 1:45 on that date? Or any time between 1:45 and 3?
My whole afternoon's available. I do not know how long it takes to drive directly here from Menominee.
Takes hour 45.
Then 1:30 would be fine.
All right, so 1:45.
1:45,
We'll schedule you
yes.
for 1:45 on March 30th. And by then you'll be able to let me know if you're going to file a motion.
Yes, Judge.
Or
It'll
will have
be
already
filed
filed.
before then if I'm going to be filing it.
All right, so Mr. Chapman, if it is going to be filed before then, quite honestly, we could remove that at that time and then Mary can just set the hearing date. So Mr. Eads, please stay in contact with Mr. Chapman to know if you need to come back on that March 30th date or if it will be moved.
Okay.
All right, thank you. We are adjourned.
Thank you, Judge.